that other stuff. Okay, we are going on the record now, and we are live streaming these proceedings, so they are open to public access in that manner. However, just given the way the day worked out at the conclusion here, we've already had the general public exit the courtroom, and for efficiency to take these matters up and also for security where the defendant is remaining present here, we are going to conduct these hearings on the live stream, but not permit public access, as this will conclude the day as well. So what the court has before it is a motion to reconsider state's motion in limine related to Upped insurance, quote unquote, filed May 22nd by the state. And at issue is a previous ruling on a motion in limine. I should note the jury is not present for this proceeding. They've been excused for the day. And so on this motion in limine, the court previously determined that a statement made by a proposed state's witness, Janice Olson, about changing the defendant's life insurance or the defendant's wife's, Tammy's, life insurance policy, I found it was not admissible in a previous ruling. And based on additional testimony now, the state is requesting that I revisit the ruling as it concerns the state's potential rebuttal. And so I will hear argument on the motion. Mr. Wixom, I understand, will argue it. And I have allowed the defense an opportunity to review the motion, and we'll hear argument in opposition if there is any. So Mr. Wixom, please submit your argument as it relates to this motion to reconsider the motion in limine.
Thank you, Your Honor. May I remain seated?
Yes.
Thank you. Your Honor, I again will attempt to be brief. I think the court is very familiar with the arguments made in the prior brief. I do point back to those points of law and authorities.
Could you pull the mic up a little closer?
Certainly, Judge.
Much better, thank you.
Yeah, you betcha. Your Honor, we're in a situation now where the court has denied our original request to call Janice Olson as a witness, who we anticipate will testify that approximately the 5 or 6 weeks or month, I don't have it in front of me, prior to Tammy's death, that she had lunch at school with Tammy, and that Tammy, in a passing conversation at one of those lunches, had stated to her to the effect of, "My husband wants me to up my insurance. He thinks I should up my insurance." And then, of course, we have an admitted exhibit as to a life insurance policy that did bear the signature of Tammy and Chad Daybell. As I recall, the date of that application was the 8th of September of 2019. It increased coverage for Tammy from $50,000 up to $130,000. It added $80,000 of coverage. There also, as I recall, may have been some request in it to add Mr. Daybell to the policy.
All right, Mr. Wixom, though, before going back, there's a quote in your motion, and that was in the previous motion. You read the first of that, and I'd like you to go back again with the entire quote in context there, because I think the rest of the context does matter in the court's decision here.
Certainly. You bet, Judge.
So please review again on the record the comment you're requesting from the beginning to the end of those quotes on the middle of page 2.
Will do. Sorry, I just have to call it back up here quickly. So, Judge, the proposed statement that we would intend to admit would come from Ms. Olson testifying, and we believe she would testify to the effect of, quote, she'd just say, I think she's referencing Tammy, she'd just say, my husband thinks I should up my insurance here at the end of my career. You know, before I retire, he's thinking I should up my insurance.
Okay, thank you.
You betcha, Your Honor. So back to that, Judge. We know that there's an admitted exhibit now where in fact an application was submitted, insurance was upped, and approximately 5 to 6 weeks after that, Tammy was dead. So the court had originally denied our request to have that admitted through Ms. Olson. What's changed from the state's perspective, Your Honor, now is that yesterday, I think is when Monday, I'm sorry, when Emma Daybell was called, she was questioned by the defense, specifically asked a couple of questions that have been included on the transcript that we have attached to our motion. And in that transcript, it demonstrates for the court that defense counsel asked Emma about the meeting that both Emma and Tammy had with, I believe it was Taylor Ballard from the insurance company that year, about the benefits. And he asked her a couple of times, very specifically, whether or not she knew if her mother had any conversations with her husband about increasing the insurance. I believe that was asked twice. I'm referencing page 4 and 5 of the partial transcript. Excuse me. The question was, beginning at line 7 on page 4, are you aware as to whether or not your mother consulted with the insurance company, with your father, prior to upping her insurance on that meeting day with Taylor Ballard? Ms. Blake objected, called for speculation. The court overruled. And then Mr. Pryor again asked, are you aware of whether or not your mother consulted with your father on that day to up her insurance? Ms. Blake objected as to hearsay. It was overruled. And then Mr. Pryor indicated that there could be an answer. Emma said, we were sitting at a table and filled out the paperwork together. We both signed to take out more life insurance on ourselves, and we did not consult with our husbands. Next question, at that point, did you take up the maximum amount of insurance that you could purchase at that point? Emma answered, I did not, because I could not afford it. I later did. Next question, okay, at the next period. Answer, yes. Last question from Mr. Pryor on this issue. But it's your understanding that without discussing it with your father, your mother elected to up her insurance to the maximum amount. Her answer was, I saw her check that box on the paper. So, Your Honor, the state believes that the defense has effectively opened the door to the relevancy of whether or not Tammy did, in fact, talk to her husband about the need to up the insurance. We believe that it's now relevant. We believe, like we had noted in our motion before, her statements would come in over any hearsay objection under Rule 803(3) as a state of mind exception. And certainly they've already been allowed to be testified to. This issue has been testified to now by the defense. So there won't be any prejudice against the defense in trying to match the evidence because they've already introduced evidence on the issue and called a witness and questioned her about it. So without belaboring it further, Judge, unless you have questions, we do believe that it's now, the door's been opened and the state should be allowed to offer the evidence.
All right. Thank you, Mr. Wixom. I don't have any further questions. Mr. Pryor, if you'd like to offer any argument if there's an opposition.
Judge, there is opposition, Judge, and the context of that is simply the words at the very end, before I retire. And if we're going to engage in this situation where we're going to be able to recall witnesses so that they can start muddying the waters and creating a confusion that at some point, Chad Daybell talked to Tammy about upping her insurance before she retires. There was no indication of when she was going to retire, how she was going to retire. And quite frankly, Judge, I don't think this falls under the state of mind exception to the hearsay rule. And the fact is that it wasn't at the present state of mind, and there is no indication from that statement that the insurance was going to be upped on that particular cycle. There is no indication when she was going to do it. And even, I question whether that comment or that discussion ever took place, but that's for cross-examination. Should the court even consider allowing this? But Judge, if we're going to start engaging in a policy where we're going to start saying the state, because now there's one minute statement that seems to suggest something other than what they're saying, and that's going to allow them to reopen, you're going to open the door to the state coming back and basically relitigating their case for another, 2 or 3, 4 days, going every little statement that they think they can gain some mileage by doing this. And it is not a definitive statement. And I think the court properly noted that when it said, listen, read the entire statement in its context. Before I retire.
All right, Mr. Wixom, I get, there's of course the initial hurdle of relevancy under Rule 401. And I understanding your argument about opening a door and letting this in. I guess one extra question I would have is the source of this proposed statement, because there can be a proffer of here's what we think a witness is going to say, and this is a very specific statement, as if it's quoted from somewhere. And so I don't know if that's taken from an interview. I don't know where the statement came from. And in determining relevancy, and I may have to have an offer or an in, well, before I get there, what is the source of this proposed statement that's so specific in the quotes?
Certainly, Judge. The source is one, the written report of Detective Bruce Mattingly, who did an interview, and there's also a recording of that interview. In my prior motion, I had referenced an offer to the court, should the court want to review that, just to avoid any question about what exactly was said by our prospective witness. And I'm happy to provide that if the court would wish to review that.
Okay, well, I appreciate you clarifying or clearing that up, clarifying it. That was a long time ago. This has been a long trial, but I do recall the issue. And again, I wanted to determine where that statement was coming from. So the court's noted the objections as indicated both for hearsay or for relevancy. The court would note that under Idaho Rule of Evidence 401, the standard is pretty broad there. Evidence is relevant if A, it has any tendency to make a fact more or less probable than it would be without the evidence, and B, the fact is of consequence in determining the action. When I look at this statement, while I still question the weight of that, with the comment saying before the end of the career in a place where she had not worked long, and there wasn't, I agree with the defense, there was no testimony about when or if she was planning on retiring. I still think this gets past the 401 relevancy test, that there may be some tendency to make a fact more or less probable. And so with that any tendency language, we get past 401 in the court's view. The court also, looking at the balancing under 403, would determine that there would be some relevancy here if the state believes this is worth bringing the witness in on that statement. Of course, the statement can be cross-examined and the jury would have to determine what weight to give it. In terms of the hearsay, I have looked at that, and so it's essentially a hearsay within hearsay statement where the proffered testimony would be a person overhearing what Tammy Daybell said Chad was saying, and Chad being Mr. Daybell, the defendant. So his hearsay gets around the hearsay issue because he is the defendant in this case, and it's charged as part of a conspiracy, and a statement in furtherance of is what the rationale would be of the state. So then the question is there another exception for Tammy's proposed statement of what she told Janice Olson? And looking at Rule of Evidence 803, whether or not that is a then existing state of mind, I do think it fits within that 803.3. And in addition, there's the catch-all under 803.24 of the Idaho Rules of Evidence that a statement not specifically covered by those others, if it has equivalent circumstantial guarantees of trustworthiness, is offered as evidence of a material fact, and is more probative on the point for which it is offered than any other evidence, the opponent can obtain through reasonable efforts and for admitting will best serve the purposes of these rules and interests of justice. The notice provision of 24 has been complied with here. And so with those two bases under 803, the court is going to allow the statement if the witness is called by the state in its case in rebuttal. So the previous ruling then, and this is specifically not because anything changed other than what has changed again is the opening of the door through the testimony of Emma Murray, who specifically did testify right on point with the issue, talking about signing the life insurance and that quote, "We did not consult with our husbands." So I think the state's allowed an opportunity to rebut that now that the issue's been brought up in the defense case in chief. And so looking at the rules of evidence under both 400s and 800s with hearsay and relevance, the court is going to grant the motion and will permit the witness to testify as to that fact.
Judge, as an instruction, am I to understand that because this is rebuttal, the state is limited to the question of what this statement encompasses? Is that the scope of what they're going to be allowed to delve into?
Well, on rebuttal on the scope, I don't know right now what they intend to get from the witness. She'll have to follow the procedure of any other rebuttal witness and be limited in scope to what rebuttal would normally allow. But this expansion would be overturning the previous ruling on the motion in limine to permit that specific statement. So I think it may well be limited to just that, Mr. Wixom.
Thank you, Your Honor. At this point, that's all the state intends to do, given, unless some other issue comes up with opening the door, but we don't anticipate that.
Okay.
We did want to comment on one further thing, Judge, and I apologize as I sit here. I don't remember, I believe that we've left Ms. Olson under subpoena and she wasn't released, but I don't know for certain. I did want to address that so we don't have a problem with this. Even assuming for argument's sake, she has been released and has watched the trial, I would just argue to Your Honor on this very narrow issue. We'd raised this before with the court. It's documented. The defense has had this. The purpose of the exclusionary order is to prevent influence of testimony. But in this situation, we all knew a long time ago what she would testify to. And so we wouldn't be surprising the defense with it. It's not going to be susceptible to influence. So
Well,
I'd raise that with the court.
And Judge, that's where I would disagree. If Ms. Olson has had an opportunity to discuss this, and it sounds like at least she's been approached by counsel with the possibility of testifying, that would qualify as tainting the witness. And the fact that she has been excused and we're going to allow her to come back is problematic for me.
I may have to consider that as she gets here in an in-camera interview if she has watched, in particular, if she watched that testimony of Emma Murray, which opened the door, and in particular, if she's listening now to this hearing, which is being live streamed. I might tend to agree that she may not be permitted to return because of she wouldn't violate the exclusionary order because she's released from the order. However, I might find it impermissible that it could be seen to have influenced potential testimony. So I would just have to take that matter up when she's called. But that's probably the first things I'd be wondering and asking is whether or not she's listened in on the hearing we're having right now and whether or not she listened in on Emma's testimony, which could potentially raise the issue Mr. Pryor's raised. So I won't make any ruling on that at this time. So that'll be the court's ruling as it relates to the filed motion. All right, moving on then, two other potential witness issues the state wanted to raise as it related to Deputy Cannon, I believe, and Detective Hermosillo.
Your Honor, Detective Hermosillo might be the quicker issue to deal with. The state had released Detective Hermosillo. I believe the defense did as well. We would let the court know that Detective Hermosillo has been hypervigilant about not watching any portion of this trial. We feel it necessary now to call him in rebuttal as to some testimony that has now come in. But he's going to come voluntarily, of course, and his representations to us, and we absolutely believe he has not watched any portion of this trial. So we wanted to seek leave of the court, given his release from the subpoenas and the exclusionary order, to be allowed to call him as a rebuttal witness.
Okay. Well, I appreciate the parties bringing this up. It's not necessarily any type of a motion. I guess it's just alerting the court and defense that there may be a return of a released witness and whether or not they're permitted to testify or not. Again, witnesses who are released from subpoenas and advised they're no longer under the exclusionary order are not going to be held in violation of the order. Whether or not there's some kind of motion to exclude based on potential tainting of their testimony, I think is just an issue we would have to take up. But I appreciate the proffer, Mr. Wixom. Is there any comment on that from the defense, Mr. Pryor?
Judge, my concern is this, is that the very witness they're talking about happens to be a law enforcement officer who's involved heavily in this case. And despite counsel's assurances that there's been no discussion, I'm extremely skeptical of the fact that Officer Hermosillo did not discuss the case in any regard with any of the law enforcement officers. In addition, this officer has been excluded and excused for a reason. The contemplation is at the time when we do this, Judge, is that both parties are not going to be permitted to call the witness back and rehash through the testimony of this witness. Now what we're having now is putting me in the position where I have a case that I've put in chief. I'm prepared to rest. The state had every opportunity with Officer Hermosillo to come forward and testify. And suddenly now, after I'm preparing to close my case, they're now bringing this witness back who has now been released, and they're going to open the door to a number of issues that, quite frankly, cannot be adequately addressed through cross-examination with Officer Hermosillo. The advantage is clearly in the possession of the prosecuting attorney, in that I'm putting him in a very, very unbalanced position by allowing the court to bend the rule a little bit and say, well, at this point, we'll let this witness in. They want Coulter Cannon in. They want Hermosillo in. I don't know who else they're going to try to get in, Judge, who's been excused. But at the minute you open this door, you're opening the door for them to rehash their entire case in chief. And at that point, Judge, I don't get the liberty of bringing witnesses back and saying, were they telling the truth? Unless this court's going to give me a surbuttal, which I don't think that's going to be the court's ruling. Allowing this to open up creates a number of procedural problems, and just the representation of Officer Hermosillo saying, oh no, I didn't listen to anything, when he's one of the chief officers in this case, I'm not buying it.
Okay, well, I will note that as with any witness, witnesses are placed under oath, and it's up to them to tell the truth if they're under oath or not. So the court's certainly not going to draw any kind of inference or conclusion that already I'm determining that the detective would not tell the truth if placed under oath. I understand the concern raised, but that does not rise to the level to me that would disallow a witness to return to the stand. I guess just procedurally, in terms of who gets called back in rebuttal, generally, there are some parameters there. And Mr. Wixom, if you'd like to address the argument of the defense as it relates to Detective Hermosillo, you may.
Certainly, Judge. Just a couple of quick points. First of all, we would just remind the court and counsel that Detective Hermosillo was the case agent in the prior case and sat through all of that trial. So he's already heard from the bulk of the witnesses in this case and their very specific testimony, although he has and continues to represent, and the state believes him when he says he has not watched any portion of this trial. Judge, the argument about just calling back witnesses, first of all, we've only brought these few witnesses to your attention that we're requesting. We anticipate our rebuttal case will take a day and a half, perhaps 2 days. It's a very small number of witnesses. Any defense in any case has to understand, and does understand, that the prosecution has a rebuttal right. We do understand that with that rebuttal right and recalling of witnesses, we have to keep it narrow and focused to things that were brought up in the defense's case in chief, which is exactly what we intend to do. We have no intention of going outside the scope of what was raised in the defense's case in chief. So Those are our understood parameters. If the court allows this, we do believe that Detective Hermosillo will testify under oath truthfully. He hasn't been influenced. And we do intend to keep all of our rebuttal witnesses isolated to responding to evidence brought up in the case in chief and keep it under that scope.
Judge, that hasn't been responsive to the court's inquiry as to the direction he was going to go in on cross-examination.
Well, yeah, I really think I don't have a ripe issue before me to decide at this point. If you call somebody and there's a reason to move to exclude or not permit their testimony, I'll rule on that. I mean, motions in limine are helpful in alerting the court to matters that may come up to think about or rule upon to not waste your time. But I don't think I have that here. If he's recalled and there's some reason the defense thinks he shouldn't testify, I can hear argument on that outside the jury's presence, of course, and I will if a motion's made. Otherwise, I'm not prepared to sit here and make a ruling and say he can or cannot testify. So that's the court's final comment on the issue on that witness. As it relates to Deputy Cannon, are we just wandering into the same type of what I think is sort of requesting a provisional ruling without a motion here?
Yes, Judge. He might be a more difficult situation for the state. And so.
Okay, well, I'll keep that in mind. And the best I could say is if there is a specific matter, discuss it with the defense. And if there's a motion with some specifics or particulars that the defense thinks should disallow recall of that witness or any other, bring it up. And I will try to take that up outside the presence of the jurors so they're not waiting. But I am not inclined to make any other rulings at this point without motions pending before me. So we'll go ahead and leave off for today. Be back on the record with the proposed schedule we have tomorrow. And if there's nothing further, then we'll be in recess at this time. Thank you.
Judge.